pass the bar. You're going to pass the bar. In these lecture shorts, you'll get good at torts. Know the laws you've got to know. So let's start, 'cause you've got an awful long way to go.
Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis. I'm the Associate Director of Bar Passage here at Delaware Law School, and today we're going to talk about the MPT. In particular, we're going to talk about some MPT tips. We're going to walk through an MPT that's very particular. It's called Rowan. You can find it online, or you can email me at the email address right here. We can kind of go over it together. The idea of the MPT is that it is a closed file memo, right? It's under time considerations. It's an unrealistic application of practical work, but it does test a lot of your practical abilities to do very particular legal things. What we're going to talk about in this lecture video is the particular ways to approach it if you're running out of time, some easy ways to raise points, ways to write, ways to think about the problem, to raise your ceiling and raise your floor when it comes to the MPT, and most importantly, give you an idea of being able to approach the problem as a practical lawyer to give you the highest score possible. That's ultimately the goal. Now, in regard to the MPT, what you're always going to get is you're going to get a case file, you're going to get a law library, you're going to get generally the same topics, even though the material might ask for different problems. There are different types of MPTs. And so the one MPT we're going to go over here might not apply for everything, but it will give you a pretty good idea of how to approach most base problems. The most important thing with the MPT is I think a lot of people get concerned that if they get a different type, that they're going to panic and they're going to fail. But one of the key things I want to talk about today is if you approach some of the rules that we cover here, regardless of what the format is, you'll set a good baseline for yourself that you'll be able to succeed no matter what. That's the goal, right? To put you in a position that no matter what happens, you're not going to panic, you're not going to fail, everything's going to be fine. Now, in general, the main approach when it comes to the MPT is something along this. This is sort of the party line of how to approach MPT review, right? Skim the instructions, read the task memo, skim the file, read and outline the law, read the file with a more detail and supplement the outline, check the task memo one more time, and write the answer, right? The point being is that if you have 90 minutes to do the MPT, 45 minutes of writing, 45 minutes of preparation, 45 minutes of writing. And that's a perfectly fine plan. I think that splitting it one half and half is a good idea. What I want to do with this presentation is talk a little bit about how to do these individual sections and really think about the idea of when you're planning, when you're outlining, when you're reading, what are you looking for and what approach should you be having? Sometimes I think the MPT just feels like you're thrown in the deep end of the pool and you're floundering. This might be the experience that you have. And so I want to kind of give you some ideas of like when you're reading the task memo, why are you reading it? What are you looking for? How do you outline? What's the point of the law library and why should you be reading the facts and how much, when I say the word skim, what do I mean by skim is a little bit different. Now, with all of these things, these are my suggestions. I don't think that in any way there's a one perfect way to do the MPT. And so I think it's perfectly acceptable to pick and choose some things that we might do and some things we might not. But in general, I think thinking about this is a collection of suggestions and picking which ones you think are best are the ones that work. Now, what we're going to do is we're going to bounce back and forth between a few different things. I'm going to talk on this PowerPoint. I'll kind of flip back and forth between the actual MPT, and we'll go over some different things to look for and what you want to be shooting for in regard to how it works. First things first, what's the first thing you do, okay? The instructions for most of the MPTs are fairly comparable. So if you read one instructions, get a good idea of it, take a little time and read it in depth, but really your starting point comes with the task memo, which is most MPTs or all MPTs come with a memo from a lawyer, a hypothetical lawyer, obviously, that's outlining the general project that you're looking for. Now, in regard to the task memo, there's two things that I think when you're reading it, I want you to be gravitating toward. And I think these two things are things that will significantly impact the ceiling and the floor of your MPT. Meaning that I think if you can accomplish both of these, you put yourself in a pretty good position regardless of your understanding of the law because you've established two really important parts when it comes to MPT construction. You can write like a lawyer and you can solve problems like a lawyer. The first thing I have here is tone and procedure. I think that this will always be found in the case file, and it essentially asks the question of why are you writing this and what is the status of the problem? Now, depending on the type of problem that you deal with, it might present some different ideas, but ultimately the tone and procedure are going to dictate how you actually write the paper. We're going to talk about what that means in a second, but one of the things about MPTs is you want to practice different styles of writing for different types of MPT. You're not going to write this document all in all the same voice, because one of the things they want to test is your ability to do different things. As a lawyer, sometimes I have to write very aggressive letters to to adverse counsel. Sometimes I have to write, hand-holding friendly letters to my clients. Sometimes I have to write very respectful letters to judges. You have to be able to use that voice and highlight it. It isn't a crazy thing to be able to do, but it is the kind of thing where the more you can practice and remember it, the more successful you're going to be. The next one I have is issue organization, and I actually think this is really, really important. It's the idea of where do you find the organization of how your paper works. This isn't always found in the task memo. Sometimes it's found in the law library. Sometimes it's found in a little bit both, but it's the kind of thing where you want to think about how are you going to organize your answer in a way that best effectuates what they want from you. This is something that can be confusing. And so for me, the organization of the memo, how I'm going to organize my points, is the highlight of where I am starting. It's the first thing I want to read when I get into the paper. And it's something that I'm not going to write anything unless I have a really clear idea of how I'm going to organize it. And that's something that we're going to help with. Now, first things first. When we talk about tone, you want to think about whether or not your paper is going to be objective or persuasive. Now, persuasive writing requires an overemphasis on conclusions and writing with confidence, meaning that you are right no matter what. Persuasive memo is that every single conclusion favors your point. In most instances, this will come off easy. I think in a lot of ways they phrase the MPT to favor the persuasive side that you're arguing. However, there will be at least one that doesn't favor you, and you've got to be able to figure out how to craft it. Now, I think that as a lawyer, I've been a lawyer for many, many years, since 2007, and I think of myself ultimately as like a mercenary, right? I argue what I am paid to argue. And that skill to be able to say, well, I don't believe this, or this isn't my preference in what the argument is, but being able to craft something anyway is something that as a lawyer, you have to be able to do. If you're a public defender, if you're a district attorney, if you're a civil lawyer, there are going to be times where you're going to have to argue things from a disadvantaged position. This is sort of the practice of where you get there, right? And figuring it out mostly is a matter of just doing your best, but not ignoring the point. One thing I think that sometimes I get people, students saying, well, I didn't want to argue it because I didn't think it was the best argument. For persuasive writing memos, they want you to feel that way. And I think that your ability to locate where that argument's located and really address it with as much strength as you can, I think is an important thing that they want to show, and something where you can show the bar examiner that, again, you know what you're doing. The objective writing is a little bit different. This is something that allows you to discuss both sides of an issue and present an objective answer. It usually starts with a conclusion, right? You give your answer, you discuss both sides, and you justify where your answer is. In objective writing, there's usually one right answer. Usually, not always, but it's usually something where the law points in a certain direction and they're looking for that certain direction. One of the important things I want to note, though, is that both of these are focused on your conclusions regardless. Whereas persuasive writing is a little bit more heavy-handed. The first sentence of every paragraph, the last sentence of every paragraph should really kind of reinforce what your conclusion is in a way that favors your client. Objective writing, again, I think that every good topic sentence should be what you think your answer is. Legal writing is sort of from the top down. Give your answer, explain why. Give your answer, explain why. And so the tone there is just a little bit different in the sense that where objective writing balances things, but I don't want it to seem like in objective writing, you can build toward a conclusion. You should always kind of stand with your first front, your strongest point first, which ultimately is your answer. Now, there's other things with other types of documents, things like statutory construction, will construction. Those are writing that you want to kind of use the samples that are being provided for you. But the main point with persuasive and objective writing is being able to distinguish what that tone is. Again, persuasive writing isn't the same as objective writing. And I think most people default to an objective standard no matter what. When you have a case file or a task memo that asks you to write a response, to write a motion, to address something within the context of litigation, you have to take the mindset that you are representing this client and you are writing to that point. You are writing very clearly in a manner that supports our argument no matter what. General hints for correct tone, unless it's a client letter, omit personal pronouns. Persuasive writing should never include things like we, our client, I believe. You're not discussing it collectively. You are discussing it aggressively, right? I should win, defendant should win because, right? Plaintiff is successful because. And that's really the point of sort of persuasively presenting something. It's conclusion. It isn't just your opinion. Practice shifting the tone of your writing before the bar exam. Play the part of the hypothetical problem. As you continue to practice MPTs, get comfortable being like, if this is persuasive, I'm writing this way. And if this is objective, I'm writing this way. Go back to your old MPTs and really think about the idea of, am I getting the tone correct? Because getting the tone correct just sets a really high floor, and I think it's an easy way to give yourself easy points. Tone is mostly found in topic sentences and the analytical sections of your writing, meaning that your first sentence should set the tone of, this plaintiff should win because, in our example, the lower decision must be reversed because, must be reversed, cannot succeed. Strong language, right? Because that's how lawyers write. But essentially, you want to remind the bar examiner that you know what you're doing and why you're doing it, and kind of remind them early and often. When it comes to procedure, right, now that we have the tone established, that we're distinguishing between, a persuasive and objective tone, we want to include references to the procedure of the problem throughout these topic sentences and throughout this persuasive writing. Meaning, if you have to write a motion, your MPT should address very specifically what your requested relief is. If it's a motion for summary judgment, you should be saying, motion for summary judgment shouldn't be granted, not plaintiff should win, not Rowan has proven. You want to kind of make sure, again, in very small ways, establishing the fact that you were able to note what that request was, and you're providing that request to the bar examiner. Appellate work for this one. There are a lot of appellate MPTs. This should be something where the order should be reversed. The trial court's decision is erroneous because. It's easy, right? And it's mostly a matter of, again, topic sentences and subject headings. If you're able to find a standard that discusses the appellate review or the standard under which the decision is referenced, include that in something like an umbrella paragraph or include it in your application section to note the idea of reminding the bar examiner, I know what we're doing and I know why we're supposed to be doing it. Now, the more important here is issue organization. Now, issue organization is how you are actually organizing your MPT regarding the individual points of proof that need to be established. I think that you can pass with incorrect organization, meaning that for the Rowan MPT, I'm going to tell you how I think it should be organized. I think if you've done it differently, it's not the end of the world, but I do think you've put yourself at a disadvantage because there are times where you've lost tone or you've lost procedure, or you're maybe missing an issue that's really important. So one of the things I think about thinking about organization is just making sure that you're being conclusive in regard to the way that the law is practically presented. Now, these are two really broad rules, right? I don't think that they're perfect for every MPT, but consider them the next time you do something when you're organizing how your points are. Objective MPTs are often organized around legal points in the law library, meaning that the court will go over the law and essentially say, this is a 4-part test. One of those 4-part tests has like 3 elements to it. This is an 8-part test and 2 other tests, right? That normally when we're talking about objective MPTs, the amount of law will seem overwhelming, but they want to make sure that you're able to write it quickly. I have often found that when the legal organization is in the cases, there's way too much to do, but they want you to do it. So if you see something along the lines that says, hey, this is a 12-point test, this is a 6-point test, to the best of your ability, organize around that test. I know that seems crazy, right? But often when I think of how to put something together, objective memo MPTs, I'm looking for my organization in the law library. Persuasive MPTs are commonly a little bit different, and I found a trend that I would like to share with you that I think is helpful. Normally, I think persuasive MPTs are organized around individual claims within the law library. And when I say claims, I mean points of argument that the task memo is going to address to you very specifically. Normally, if the task memo has some kind of numbered list, something that's either, again, in the task memo or early in the fact file, where there's a collection of arguments that need to be addressed, that commonly is how you should address your MPT. So I look for points like that and say, okay, If this is what they want me to do, I'm going to start with that position and then I'm going to move forward from there. Because practically, if there are claims in a motion, right, like you think about complaints, complaints are very rarely, I'm suing you for just negligence. Usually it's like negligence, recklessness, responding as superior. And if you have a motion for summary judgment, it has to be this point is wrong, and this point is wrong. When you have an appellate argument, normally if there's appellate argument and there's different structures, which the MPT may provide for you, you want to organize around those legal arguments to make sure that the organization is clearer than trying to organize around individual points. So when we talk about persuasive MPTs, we're going to think of it two ways, right? The big picture point is that you want to focus on arguments, right, over factual conclusions. The hint that I want to give, and this might not be true for any, but they've been somewhat consistent, at least for me, is looking for some kind of numbered list, some kind of organization, the task memo that hints at what they want to provide for you. Okay, this is our Rowan MPT, and this is the task memo that I had mentioned before. Now, one of the reasons why I like the task memo and focusing on it is that normally it's going to provide you a good amount of facts and essentially the argument that you know you're going to have to address. When you look here, what you're normally seeing is you're addressing the fact that you're representing William Rowan, the British citizen. Okay, that's important. You're also noticing that he seeks to remove the condition for his lawful permanent residency. Now, I will note, I'm not an immigration lawyer, so I knew nothing about law going into this, but it was important to note that, like, we are representing somebody who's seeking to remove a condition on something, right? It also notes the fact that there is a contrary relationship between Mr. Rowan and his spouse, and it also addresses the fact that he lost at a lower level and he seeks to review it. Now, because we know that we're arguing a practical legal document, we're going to know that our tone is persuasive. Please draft our brief to the immigration judge. We'll need to argue that Mr. Rowan married in good faith. It should argue that the immigration officer's decision was not supported by substantial evidence in the record before him, and the totality of evidence supports granting Rowan's petition. That, to me, is the most important paragraph in this entire task memo, because that, to me, is the organization of how I'm going to put things together. I know that I have to argue, right, that he married this person in good faith. And my 2 points that I think I'm going to argue around is, one, the decision wasn't supported by substantial evidence, right? And the totality of the evidence supports granting his motion. I don't know what that law means right now. I don't know how to fully vet that out. But I'm going to try to think about it from now. My perspective is I need rules about overruling the substantial evidence standard. I also need rules on the totality of the evidence standard. That allows me, at very least now, to look at the task memo and say, all right, I know what I'm arguing. I know what my points are, right? And I'm just moving forward in a way that I think is productive and has a good understanding of where my writing needs to be and where my rules need to be constructed. So now that I know my organization and I know what kind of issues I'm going to put them on, what I would probably do now is on my Microsoft Word document, or whatever I'm writing on, I'm going to write these 3 sentences. I'm going to have an umbrella paragraph heading. The director's denial of Rowan's hardship waiver must be reversed because Rowan's marriage was entered into in good faith. That's my main argument. I know that's my argument. The director's decision must be reversed because the totality of the circumstances support Rowan's marriage was entered into good faith. That's my element 1. That's the one I'm going to go over first because I think that might be easier, but this is a 6-1, half dozen another. The director's decision must be reversed because the director's decision is not supported by substantial evidence. Those are my topic sentences, right? If I can get them on the page, I know what my organization is. So often when I know my organization, I know what my points are, I'm going to create topic headings so I know where to write. And my big thing always is like writing rules first, which we'll get to in a second, to me is paramount. So I think that when I have this organization, I can highlight rules, I can write an outline as much as I want, but if I can just take the sentences and put them on the page, to me that saves a little bit of time. That's how I write. Again, that's how I do it. But I also note the idea that at very least this sets the benchmark of how you want to write so that you know what your plan is, right? So that's my plan. That's going to be on my Microsoft Word document as I kind of move forward. Now, if I move over to my facts section, all right, now I'm going to give you some dangerous advice, okay? This is what I do. If you don't want to do it, that's cool, but we got to meet somewhere halfway in the middle, right? Read the facts section as quickly as humanly possible, right? I think that you don't know what you need to know, right, until you know the law. And so the problem, I think, with reading a fact section before you know everything is that, one, you can think you know the problem before you actually know the problem. You might assume, well, I remember it, which you definitely won't, right? And more importantly, I just think it's a time waster. I think with the MPT, a lot of what it is, it feels like a racing video game to me. Bear with me on this one. In that, when you're playing any type of race, you're just trying to shave edges off the corner. How do I save 10 seconds? How do I save 2 seconds? How do I get around this where I'm not bumping against an edge? I feel like a fact section is the kind of thing where you're only using the fact section to show the bar examiner that you know what the most relevant facts are. Right now, where we are, have no idea what the relevant facts are. So what's the point of getting super into depth on something until we know the answer? Now, if you don't know what your issue organization is, by all means, breeze as much as possible, but resist the urge to try to read this with any level of depth. Personally, I really try to put the least amount of emphasis reading on deposition transcripts or trial transcripts or interviews with people. I feel like depositions, particularly from non-lawyers, are mostly about things that you only need to know or understand after you read the law. Now, again, you don't do that immediately if it fails, right? But the more comfortable with you get, try to get through it as fast as possible. Because I think that the level of detail you really need comes after the law. And I also tend to think that you don't want to bias yourself, or you don't want to kind of take the time, the really detailed time that you need later on, right? So let's go to this MPT and I'll show you kind of how I would approach it. All right, so the first thing we have here is the law offices of the office. As I'm reading it here, it seems like a client interview where the client's just telling the story. To me, this stuff only really matters later on, and I don't want to dive too deep into factual circumstances before I really need to know them, especially in the fact of the idea that if I highlight anything, I don't know what's ultimately as important as I ultimately may need it to be. Here you're getting a petition regarding from the affidavit of his wife. Again, I don't know anything about the relationship. I know nothing about the law. To me, I'm not going to read this almost at all. And then finally, you have the preparation from the investigator of the information that was provided. I think that when it comes to a practical document like this, I might put a little bit of information here. But as you see, all it is witnesses and documents later on. This stuff will come up later. I think that this is really, really important at a later context. But right now, I have no idea what I'm looking for. I have no idea what the legal standard is. So I'm going to try to really give this the amount of time I gave right now. 30 seconds, absolute max. I know I have some interviews. I know I have some documents, an affidavit, but I'm going to move on because at the end of the day, I'm going to save the greater detail, the greater time that I have until I actually know what the legal standard is. Now, this to me is the interesting part, right? This is the law library. This is the first place where you want to find really in-depth information. Now, it's great to read everything, but let's talk about why we're reading stuff before we're reading it and what we should be really looking for. The law library will usually contain two different types of authorities. There are some variations. Obviously, you could see some things that are a little different here and there, but ultimately what you're going to see are statutes and/or secondary authority. Usually statutes, sometimes secondary authority. The statutes are often written broadly with a lot of extra unnecessary language, like statutes tend to be, right? Statutes aren't written for you to understand something. They are written to govern the people willing to be governed. So there's often a lot of superfluous language, a lot of sort of indentations, and they're always going to provide you with more than you need. Statutes should be thought of in this context as not for, let's say, not for really in-depth analysis of something, but I tend to think that this should be used as topic sentences, broad rules that can start your discussion, but also that they should be edited down for relevance, right? That you should be using these within the context of what you've already created, but using it for the idea of how do I take what's here, only what's here, and really try to tailor and parse it down so I'm not wasting a lot of time and energy. Talk about that in just a quick second. The other part that you're going to see are cases, which are there to explain or establish the rules. Now, there are usually going to be 1 to 2 cases, but that those cases will often have embedded case illustrations within those decisions. All of the cases should be used to the best of your ability. If you can use them, use them. And neglecting using them to me is something that really affects the practical explanation of your abilities, meaning that all law requires rules and application. That's like a non-starter, right? So the point about using the cases is that every conclusion you have needs a rule paragraph based on the cases and based on the statutes. So whenever you're analyzing a problem, it's wonderful to say, well, Rowan established a good faith marriage because they lived together and they shared assets and they were in love. Cool. Why does that matter? Right? What part of the law establishes the relevance of those facts? And so when I'm writing everything, particularly my cases here, I'm looking for sentences that elaborate on the law and explain the law. I'm also finding case illustrations, which are descriptions of the law in practice that help me explain the practical application of the law. I personally think that over-reliance on case illustrations is a problem in MPTs, meaning that you are not going to say, we're like Hua, we're like Connor, because we're not like those. We could be supported by the rules, right? But until we establish that we are consistent with the legal standards that are relevant to the problem, right? We are only like those to the extent that they're factually similar, and that doesn't give us the answer that we're looking for. So when we look at all of these, I want to note that we are not reading them to draw a direct comparison. We are looking for types of rules in all of these sentences so that we can craft rule paragraphs that are relevant to our problem. Now, before I go over them, I'm going to jump ahead to one of my slides. This is my favorite slide I have in my entire teaching profession. Love this slide, right? Because it talks about 3 different types of rules that you should be included in your rule paragraphs, right? Broad statements of the law, practical ways to prove the law, and then finally, case illustrations, right? Broad statements of the law of the definitions, right? When we talk here about definitions, we want to know what is the substantial evidence standard that a director of immigration has to meet. We have to find that language within the decision. We have to find what it means to enter into a marriage into good faith. That's our starting point. And we have to tell the bar examiner or this hypothetical person, right? This is what the word means. To me, this is what I'm looking for first and foremost. And when I see it, I'm writing it. Right? You'll always see it. It's always kind of in the same place. We'll talk a few places about how to read through the law and locate the most important information. The second point are practical ways to prove the law. These are things along the lines of like, what are elements that the court looks for? What are standards? What are burdens, right? How do we write about the law objectively? A substantial evidence standard assesses credibility, but only with cogent reasons. That's a great sentence, right? Because it talks a little bit about how we view these words and we show that we can understand them. If you can include this middle section, you're going to have a really high ceiling with your writing because it shows that you understand that like the rules are more than just definitions, case illustrations. Now with case illustrations, my problem with case illustrations in the MPT but all legal writing is that I think students emphasize telling the story and then saying we are factually similar. That's book report law. I think a good case illustration is the tip of the spear, right? And what I mean by that is that a case illustration should be written in your own words to tell what is the case about, right? Who establishes that when the applicant is not the fault of the divorce, then they're okay, right? Connor establishes that credibility matters, but it has to be proven by clear evidence that includes lying, right? It doesn't just say, in Connor, the applicant was lying and therefore his application was denied. That is not the same thing, right? The point there is that I want your case illustrations to think about, can you avoid telling me what happened factually? And can you explain to me about what this case says about the law? This is a hard thing to ask of you, but I think that the better you can take writing about what you think the law represents, the better off you're going to be. You're always going to doubt yourself, but I've often found that when people take chances writing about what they believe the law to be, they are usually successful. It's usually better than just taking those words verbatim. It takes a little bit of trust in yourself. But I would like you to take the idea of this slide now dictates how you approach the law. I want broad standards. I want practical ways to prove the law. I want examples of the law in practice. We're going to start with the statutory section, right? Now, the statutory section, as you're going to see here, you're going to see 2 pages of statutes. And the pages of statutes are often going to be in some kind of organization like this. My apologies for my wonky PDF presentation. It's usually like A, subsection 1, subsection C, subsection 1, subsection A, right? All of these paragraphs together. The point I will note about this is that like this is not going to give you your answer, and it isn't all going to be relevant for the point of what you have, right? Like requirements for a timely position and interview for removal condition. In order for a condition established under subsection A of this section of the alien spouse to be removed, the spouse and the petitioning spouse jointly must submit to the Homeland Secretary a petition which requests removal of such conditional basis. Now, we know that doesn't apply in our case, so that's irrelevant to our problem. It is included, right, because it's part of the statute, but we know that it's not included in our problem because we have two people who are angry at each other. So like, don't include subsection C1A because that isn't relevant, right? What's relevant is more 4 and B, right? The Secretary remove the conditional basis of the permanent resident of an alien who fails to meet the requirements of paragraph 1 if the alien demonstrates that a qualifying marriage was entered into in good faith by the alien spouse, but the qualifying marriage has been terminated and the alien was not at fault in failing to meet the requirement of paragraph 1. Now, the point that I would note about this, statutory language is not clear and it doesn't make a lot of sense. So like, what does subsection 186 AC4B really mean? Well, it essentially means that a person who wants to have their conditional hardship waived for a terminated marriage must show that the marriage was entered into in good faith. Like, what's easier, my sentence or that language? I think that the part where people waste time, and I think it waste time unnecessarily but also unhelpfully, is just writing all of that language in all of this paragraph, because again, it's just a waste. It doesn't help you. It doesn't show the bar examiner that you know what you understand it. It really just shows the idea of like, I've located something and I don't know what to do with it. So I would advocate for you when you're looking at statutes to take the approach of the more you can edit the language down, the better. Okay, now here we have another language that seems similar, but I will note the idea that although this here feels repetitive, this here, adjudication of waiver process, right? What you have here is a waiver of application based on the claim it was married into in good faith, must consider evidence relating to the amount of commitment by both parties to the marital relationship. They include documentation to the degree the financial assets and the liabilities were combined, length of time they cohabited, birth certificates of children, and other evidence deemed necessary. I like that section. I'm going to give you a little bit of foreshadowing, but not all of it's relevant. They don't have any kids, right? And so I'm going to argue the idea that the standard under which the director has to consider the application is one showing of considerable evidence of the amount of commitment, which includes documentation of commingling of financial assets and cohabitation during the length of the marriage, right? Including but not limited to. That way it includes subsection 4. But I'm again going to paraphrase this language so that it's clear for me, it's clear for the bar examiner, and it shows that I know kind of what's important. For now, before I know the law, I'm going to isolate the idea that those two sections seem relevant. His burden, director's burden. And I'm going to just sort of keep them in mind, even though I'll kind of, again, sharpen the point a little bit later when I start writing. So just reviewing that and then giving you some examples here, right? My subsection AC4, the applicant can request a waiver of conditional residency status by terminated marriage if the alien can show the marriage was entered into in good faith. Maybe not like the greatest sentence, sharpen it a little later, but to me, that's going to go right under my subject heading, right? Like if I go backwards to this point right here, to me, that's going to go under element 1, right? That's my first sentence. That's the topic that I want to kind of include. The second one, when considering this burden, the director must consider evidence relating to commitment by the parties of the marital relationship, which includes but is not limited to commingling assets and cohabitation, right? It's a summary, but I do tend to think it's a summary that takes a lot of that complicated language and it makes it easier to review. So those to me are the broad statements of law that I need from statutory language. I'm going to put them under each element to make them as clear as possible, and I can get started looking at cases and really kind of getting an idea of what do those two things mean so I can add a little bit more content to it. Now again, statutes are topic sentences. That's what I'm looking for. I might not know where the key topic sentence is, so it might be something where I read the statutes first, I read the law later, I come back to it. But to me, my goal when it comes to the statutes are, where is my starting point, right? I think of the law as sort of like an upside down triangle. I start broad and I get more narrow. Trying to decipher and summarize what parts are helpful and what parts are not, I think are a key point of practice that I think can be helpful. Let's talk about the cases and we'll talk about a few things that we can gravitate toward them that can help develop our rule a little bit further. Okay, now a few things here I want to note with all cases. Again, I'm not going to sort of go through this with significant detail, but I just want to point out a few things that I think might be necessary. First off, whenever you're dealing with a case like this, normally cases in the MPT, but also in real life, talk about procedure first, facts second, rules third, application and conclusion that follows the rules. I bring this up only because in a lot of instances, there's going to be a very long factual section that precedes the relevant law. Like you can see on HUA, you've got this left-hand column that talks about the HUA's relationship. This is again, this somewhat dangerous suggestion, but I think that like if this information's really relevant, it's going to be referenced in the application section later in the decision. Read it, but reference the idea that like the really important content isn't going to be here specifically, but it's going to be a little bit later on that's going to provide you with the law that you're really looking for. If we kind of scroll down here to this decision, this to me is the area where I think the law is most important, and it's going to consider the idea of what law we really need. You know, in here, sent paragraphs like this, it's well settled law requires us to assess the entirety of the record. Right? Hua's husband, not Hua, initiated the separation after Hua publicly shamed him by retaining counsel and detailing his affair. We conclude that the Secretary's decision lacks substantial evidence as a whole, and thus the petitioner has satisfied the good faith marriage requirement. You know, what I'm looking for here are what's relevant in this decision that's going to help me later on. As a summary, this case includes content that talks about what it means to establish that you entered into good faith and then how you deal with the termination of the marriage. The content here where it talks about what they were, what they included, commingling of assets, living together, you know, all those things that are relevant about like the relationship. Again, not apples to apples, but the better you can summarize them, I think the better. But the more interesting thing about this decision is the idea of the termination of the marriage. So much about this decision includes content here about why her application was denied, and particularly this idea of her husband having an affair and why the marriage was terminated. Now, in our problem, we don't have that same connection, right? In our problem, you have a different reason why the marriage was terminated. I'll get to it later. But one of the points that I think is important is like, if the court's going to talk about this with such level of detail, it's going to be relevant later on. And so I'm going to put a pin in this, and I'm just going to kind of put the idea of, the rule here is that if you're not responsible for the termination of the marriage, it can't be held against you. Super easy summary, right? It summarizes HUA in a really easy way. It favors my client and it's persuasive. And so it gives me a good idea of like what I want to address and what I want to use the case for. If I scroll down here to the next case, you have Connor versus Chertoff. Now, one of the key points is that both of these cases deal with like the same law, which helps me out because in both instances, they're talking about the standard of law that's applied, right? How do you meet your burden? How do you address reversing that burden? In this case, you've got a person who did not meet the good faith standard, and they kind of talk about the idea that he's like an absentee husband, he's not doing super well. But one of the key points that I want to note is they talk about him being a liar and very particular credibility determinations. Things like this. Under the substantial evidence standard that governs our review, we must affirm the order under the relevant as reasonable minds might accept as adequate to support it, even if it is possible to reach a contrary result on the basis of the evidence. That is a practical ways to prove that standard. I want that sentence in my MPT, right? Because it shows what needs to be reviewed and it has to talk about the law. If you go to the next paragraph, adverse credibility determinations must be based on specific cogent reasons, which they provide here. In this case, they talk about the idea that it was reasonable not to believe this guy because he had lied repeatedly, right? He didn't provide good information. He lacked evidence. And so this to me is the extreme example that we want to distinguish from our problem, right? I want to look for the idea of who are we more like? Are we like Hua, who had all this evidence that she was in like a good, loving relationship and then she got cheated on? Or are we more like Connor, who, fake person, by the way, not a very good dude and seems to be lying about things, right? That's the balance of two different points. Now, before I go too far, I want to note one other thing. Commonly, and this is commonly found toward the end of the application section, and it always comes off as this little button point that they leave at the very end of a decision. They'll have a paragraph here that addresses a point of law that seems out of place, but's there for a reason, right? Connor claims that Moore's affidavit was inadmissible hearsay and it amounted to an unsupported opinion testimony on the ultimate issue, right? They bring up the idea that federal evidence rules don't apply. They must only be probative and fundamentally fair. Now, one of the points I want to note here is that we have an affidavit of somebody that isn't present. It says it in the task memo. She didn't come here to the original hearing. She only submitted an affidavit. I have to address that, in my opinion, right? Now, is her affidavit fundamentally fair and probative? Possibly objectively, but me, Brett Bendistis, the lawyer, is going to argue that it's not. And my ability of proving why it's not is something that might not be a winning argument, but it's not something I want to leave on the table. And so even here as you see it, don't let it stick out as a sore thumb to you. If you see something that seems odd legally, at least take a few beats and figure out where does it fit within the problem. I feel like if this is hearsay, my original point was that's got to go to why the lower court's opinion was not supported by substantial evidence. It doesn't go to his level of proof. That to me are the factual arguments in both Connor and Hua. The substantial evidence to me is more an idea of they misdid his credibility and they relied on hearsay evidence. So that to me is really what my arguments are and the law and the construction of what I want to put together. Let's put a few of those ideas on the PowerPoint slide and kind of cover a few clear rules here, right? First is, again, find the most important rules, put them on your paper, right? Find rules that discuss the explanation and procedure in proving key points. And so my first review, the thing I'm looking for in those decisions, first and foremost, are rules and rules alone. I'm not trying to figure out who won or who lost. I'm not getting bogged down in the facts. I'm just looking for rules. Number one. The other thing I'm going to look for is if I'm looking for case illustrations and application, I want to be able to write the cases in my own words to prove the points I want to prove them. This is especially true with persuasive MPTs where, who establishes the alien is not at fault when the other spouse breaks up the marriage, right? Connor establishes the credibility of an applicant who lies, right? Now, those facts may not be there. Right? We don't know anything about the facts yet. But the point is that I'm going to try to make sure there's some level of connection that supports my point and can distinguish this problem from my problem to best support my argument. My key thing is my case illustrations aren't going to just say Connor had someone who lied on their application and therefore it was denied. Again, that doesn't tell me the standard. It's about credibility and proof of credibility because that's a comparison that I can make with a little bit of more strength. Now, try to avoid getting down by more facts in the rule. Limit the initial fact description. It'll come up kind of later on. When you have multiple cases, I look at it as like a case illustration sandwich. That one's all me. Thank you very much. In that I take two extremes and I try to push my client toward the extreme that's more likely. It's rare you're going to have a case that's on all fours with your problem. They want you to figure out, how do I compare something that isn't the same? How are we more like Hua and less like Connor? Because Hua won and Connor lost, right? This is usually something where painting the one side as being closer to you, I think, is relevant, right? That it's not about adultery. It's about a spouse choosing to leave, right? And that credibility is about proof of lying, not like the underlying circumstances of who says what and when they say it, right? And so kind of to phrase the rules in a way that, again, creates a rule the court has to follow, I think that's really important. And then finally, look for odd rules that seem out of place and make sure you use them. Now, if I scroll down here and we talk about how I'm going to generally outline the law, I'm going to first start with my idea of Rowan met the burden of a good faith marriage. I'm going to use the statutory language that I used before as a broad rule. I'm going to make elements from Hua about cohabitation and sharing assets. I'm going to discuss the termination of the marriage not being the fault of the applicant. It's what I generally believe the rules to be, right? I'm then going to go back and I'm going to say that the director did not apply a substantial evidence standard. I'm going to talk credibility. I'm going to talk hearsay. What this does is it allows me to not get too bogged down in point one and to show the bar examiner that I understand the law, which is more vetted out in point two, right? Here's my thing. Any person, lawyer or non-lawyer, I think can be able to say, hey, cohabitation, that shows that you're in love. Sharing assets, that shows you're in love. That doesn't show that you're able to be a lawyer, right? What shows that you're able to be a lawyer is to be able to connect really particular analytical dots to make sure you're showing the bar examiner that you, again, know how law is being practiced. And therefore, although two might seem harder, I think two raises your ceiling, even if you maybe don't believe them as strongly or the law doesn't favor them. Meaning that if your entire MPT is based on the idea that, hey, they live together and they're in love and they shared accounts, I think that you're underdeveloping the most important point of the MPT, which is to show that you're really able to establish the law and you're able to kind of show an analytical understanding of the law. Now, here's my point. I know my standard. I know what I want to prove. I want to show the connection, the relationship. I want to show termination, right? I also want to talk about adverse credibility and I want to talk about hearsay. Okay, now, I haven't read the facts at all, between you and me, right? But the point there is that, I know what I am looking for. I am looking for what was their relationship before they got married, right? How did they act when they were married, right? And why was their marriage terminated? Hopefully not at the fault of our person, right? When I look at the director credibility, I remember that there is the investigator's memo. I want to look for some type of inconsistency there. Is there any proof of lying? Is there any proof of an underdeveloped record? If not, that's going to be my point. And then finally, when it comes to the hearsay argument, I'm going to look at that affidavit and I'm just going to try to poke holes in it. Listen, I'll tell you the truth. The hearsay argument is not great, but it's the kind of argument that as a lawyer, I can't leave on the table. Don't overthink the obvious. I read a lot of murder mysteries in my free time. I know I'm so cool, right? But I think that when it comes to murder mysteries, it's like the idea of how do you make something obvious, right? The boyfriend did it, the husband did it, the wife did it, and make it interesting, right? And not overthink the idea. To me, I think that sometimes people overthink the idea of, well, I can't include this argument because it's not going to win. Well, you're going to lose all the time, right? As a lawyer, you lose constantly. And so the idea of overthinking the answer, not seeing what's right in front of you, is that if that hearsay argument wins, you win. You win if that hearsay argument is not there because all of the bad evidence is included in that affidavit. So you have to give it a shot, even if you personally might not think it's the best argument. Don't overthink it, right? If something's right in front of you, don't try to make it that you are undermining your argument. You just have to write with confidence because you'd be surprised what people will believe if you can say it confidently enough. So that hearsay argument, if you skipped it, I do understand, but it's a mistake you can't make again in the future. Let's look over the facts real quick, and I'll point out some things that I think are relevant. Okay, so when I'm kind of looking at this, I'm going to look for the ideas of, what's their relationship like? How do we prove that they were good faith and that they were in love? Now, again, there's a lot of detail here that I just want to point out that might not be as relevant as it might seem from a personal level. I think the idea, he says it was love at first sight for him. I think that's important to note. He asked her out, but she refused several times before she agreed. After several weeks of courtship, he said that he felt she shared his feelings. They moved in together about 4 weeks after their first meeting, and they lived together for the balance of time in Britain. To me, I'm going to phrase it as they lived together and there's proof of cohabitation, right? That to me is the most important thing. He proposed marriage, they agreed, and they got married. Also important, right? They agreed to move to the United States together. Also important. You want to highlight the idea that the most important facts are the ones that support yours. So if who was established by a courtship followed by cohabitation, we've got that. And so that's the kind of point that I want to include. Am I going to reference the fact that he asked her out and she said no? I don't think I'm going to, frankly, very much, because I don't know that helps my argument. I don't need that information. I want to highlight what's good, and I only have 45 minutes to write everything. You're going to note this paragraph here. Obtain a job at Franklin University. They leased an apartment together, shared living expenses, right? They had a 2-year lease. They co-signed loan documents. They had health insurance. They had next of kin. They filed joint tax returns. That is something where I'm going to include this in my analytical section, but I'm also going to prove it as They established proof of good faith because under the statute and under HUA, because. It's not going to be, I'm just going to reference the material. I'm going to qualify why that information is important and why it's there, right? If I scroll down here, I'm going to note the idea that we are going to eventually talk about why they broke up. And why they broke up is that she went to a job, she got offered a different job, and he said he didn't want to leave. Now, a few things that they will note. He made as strong case as they could that they should stay, argued that he couldn't leave. She chose to leave, and then she left, right? Now, one of the things about this that I think is important is that she also said she thought he was going to stay, and they worked it out together. So I'm going to phrase this as the reason their marriage was terminated is because she left after they tried to work it out, right? You don't have to give me all the dates. You don't have to give me all of the different versions. I think that with the time you have, you can summarize it in a way that best effectuates how this relates to HUA. It's not the same. I think that having a public affair and cheating on someone is very different than following your job somewhere else. But as a persuasive lawyer, you've got to argue why it does relate it. So this is kind of one of the points that I just want to note is this factual circumstance is the kind of thing where, yeah, the facts are important, but what's important about that particularly is noting why it matters in the context of the decision. If you had read that previously, you might be like, Rowan, what a monster. Why is he leaving his wife behind? But in the context of knowing the law, you know how to spin it and you know why it's relevant. If you go down here to the affidavit, what I'm looking for here is a matter of how can I attack its probative value and the credibility of the decision. I'm going to argue here that a lot of what she's arguing, especially here, I believe now he saw our marriage primarily as a means to get to U.S. residency. She's testifying as to his intent, and she's not being there for, she's not being there to give just facts. She's commenting on his understanding and attacking it. That to me seems like a problem. The other thing I'm going to also try to attack is the idea that a lot of her evidence here does sort of note that there is a good faith relationship. I do think his affection for me was real, right? That to me is the kind of thing where it's entering into the marriage in good faith. His choice of friends, residency, and career goals mean a lack of commitment later, but I often tend to think that those are the kind of things that you can sort of still point to the idea that he entered into the marriage in good faith. Similar, he had carefully evaded any long-term commitments, including children, property ownership, and similar obligations. That's the kind of thing where she's commenting on his mental intent. That's the kind of thing that you want to say. If she's going to do that, she's got to be there. I often find when it comes to a lot of the fact section, I want to use sentences against people. And so I sometimes look at the fact section as places to find ammunition just to make my arguments, and that's it. If I look up here and I'm looking at what her job is, it's wonderful this fake person lives in London, England, but I so radically don't care that the only thing I'm really caring about is the things that actually matter to me. And so I'm trying to find the relevancy in things, but not getting bogged down in what doesn't matter. Finally, when I look at the law office, it's why is this information here? Well, what I know is that it's a point about credibility, and it's about the substantiation of the record. The substantiate of what they have here, right, are two pieces of evidence that talk about how they're in a relationship and how they've met the standard, right? And all of the witnesses support our argument. All of the documents support our argument. And what's missing here is any evidence of lying or not substantiating your record, which distinguishes us from Connor. Now, are we going to win? I don't think it matters because, again, these are fake people. But what it does do is it establishes a brief and it shows why you're using this. So my other point I want to note is that every document serves a purpose. And so the argument here is it's not met by substantial evidence because all of the evidence in the investigator's file supports that it's in good faith, and there was nothing there credibility-wise that supports that evidence on the record. So one more time, just going over what we had seen before and kind of incorporating them more specifically into the problem, right? Draw comparisons, don't overthink the connection. Again, making sure that, again, you're persuasively writing, so you're arguing no matter what, you're using a piece of evidence that you have. Burden of proof, I'm going to use the cohabitation, the commingling of assets, emphasize the evidence of a public marriage. People said they did it for love. Wife broke up the relationship, not him. And just that it's more like Hua and less like Connor, right? So my rule construction is mostly going to be on the idea of I'm going to phrase it as this what needs to be proven, this is what doesn't prove it, we're more like this rather than that, right? Also, when we talk about substantial evidence, I'm going to talk about that the file contains evidence consistent with the factual finding and point to it. I'm going to point at the idea that there's nothing substantiating credibility finding, and then finally noting the idea that the affidavit was inadmissible hearsay and being very particular. Now I have my outline, okay? That's a lot, right? I admit it. But what I'm doing is as I'm reading it, I'm taking rules and I'm putting them right on the page as I'm writing. Obviously, I'm not doing it here while we talk about it. But the better that you're able to think about rules first, application later, is I think the better construction. Now, I'm not going to show you a very particular legal document because again, we're on YouTube right now. But the point that I want to note is that highlight the drafting of rules first, application section later. Writing in vigilant CREAC form. You have to write in IRAC CREAC form no matter what. That is the standard under which they want to see. Making sure that you have one rule paragraph, right? And then I think at least one application paragraph. Two, if you've got more points to prove, right? I'm not saying you have to limit it, but I think every paragraph needs a strong topic sentence, and you want to avoid these standalone paragraphs. I don't want standalone case illustration paragraphs because they don't serve a point. If you want to have case illustration paragraphs, you better have the best topic sentence that talks about the law, right? If you want to say, cases involving a totality of evidence standard emphasize cohabitation and commingling of assets. And who has said this? In Connor, they said this, and then you analyze it. I guess that's fine. But with the time and the energy you have now, just include it in one paragraph. Also think about the idea of avoiding long paragraphs that mix law and fact. I like to keep them very separate. All the rules first, all the application second. That way the reader knows how it's written. Legal writing is written that way. Lawyers are accustomed to reading that way. And so making sure that you have a strong delineation between those 2 points, again, shows that you understand the practical components of legal writing. You understand the focus of what you're looking for. All conclusions must have rules and application. Case illustrations aren't rules. So if at any point you started a section by saying, in Hua the court said this, in Connor the court said this, I would strongly advocate for you to tell me the rules first, then give me the case illustrations. Describing a case and then giving your application is not legal analysis. That's a book report comparison. So really push yourself to be able to say the case illustrations are not the rules. The rules are found within the cases and I have to articulate them a little bit clearly. My personal pet peeve is I hate legal writing that says in Loa Hua, the court said that a substantial evidence standard means this. Just get rid of the case illustration and cite it at the very end. Substantial evidence standard is this, cited with Hua. That way you're cutting out the original point, you're giving the rule, you're highlighting the rule in its strongest manner, and you're writing persuasively. Making sure every paragraph has a strong topic sentence. Rule paragraphs should start with the broadest rule. Application paragraphs should start with a very clear conclusion with the word because, right? My last point is analysis over storytelling. To the best of your ability, and I struggle with this too, your application paragraphs need to tell me this law is proven because, the law is proven because, the law is proven because. Avoid just focusing on facts, telling me about the relationship, going over what they commingled. It's only relevant because the standards justify it. The statutory requirements of the CRF are proven because they commingled assets. The spouse's termination of Rowan's marriage matters, right? Because in Hua, they established the blameworthy consideration. This is met because she left, not him, and they worked it out together. So those are the kind of things where it's a matter of working on those sentences and making sure they're clear. Now, if I can give you one last point before we leave and a way to think about something, especially regarding the MPT. In my experience with bar prep, when I talk about the MBE, people always say the same thing. When I get something wrong, when I'm done doing 100 questions, I go back and I see what I did wrong, right? And that's great. That's perfect, right? No one ever says that about essays or MPTs, right? They're always like, oh, it's done. I'm leaving it in the garbage and never want to think about it again. Consider after watching this video, going back and reviewing one of your MPTs and just saying, did I do these things? I think that when we went over the attack plan here, I think it's very reasonable to think of it as like, oh, it's a 45 minutes. I've got a practice for taking the bar, so I'm going to do this under really clear time constraints. Sure, if you're taking the bar tomorrow, But if you're taking the bar months from now, 2 months from now, 3 weeks from now, think about this. Can you give yourself an unlimited time to prep and then a limited 45 minutes to write? Right? And then you can kind of scale the time down, right? If you want to get it perfect and you want to figure out how to do something, can you go an hour and an hour? Sure, you've got to shave it down later, but when you're just starting and doing something differently, consider the idea of whether or not to get the right points, to see the right law, to write the case illustrations correctly, can you give yourself a little bit of a buffer so you can prepare? In my opinion, I think giving an unlimited preparation time and then really focus on writing in 45 minutes is a great starting way to practice, and then shortening it to 90 minutes as you get closer to the bar exam. I also think when it comes to MPTs, they're only 90 minutes, And so when you're studying for the bar, I think doing one of these a week, one of these every 2 weeks is a brainless activity, in that you don't have to study for it. You just sit down and you do it, and you don't have the same level of prep that I think comes into like watching videos and doing MBE questions. And so get yourself in the right mindset, but consider the idea that every time you take one, you learn from it. The expression with bar preparation that I like to focus on is that you don't want to have the definition of madness, doing the same thing over and over again and expecting a different result. Think about when you're done these, what did you learn? What can you do better? How can you write it stronger? Where did you miss the organizational point? Where are some facts that you maybe, didn't leave in? And I think that to me is the key of getting better at it. This to me is something where if you can raise your floor on the MPT and raise your ceiling, it covers a lot of warts in some of the other sections if you might struggle with. If you have any questions about anything I've gone over in this video, you can email me over here at my email address, and I'm more than happy to cover it with you. If you're a Delaware law student, I'll read MPTs that you have all day long and make any suggestions that might help. Otherwise, good luck, and I'll talk to you soon.
Pass the bar. You're going to pass the bar. In these lecture shorts, you'll get good at torts. Know the laws you've got to know. So let's start.